Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm here today to answer your employment law questions over the next half hour. So feel free to put your questions in the chat. We're going to try to get through as many of them as possible this week before Christmas so that you have the answers that you need for the end of the year. Get your answers, get your questions answered today. Put the comments in the chat. We also have a lot of information online at our website at stlawyers.ca, employmentlawyer.ca rather, employmentlawyer.ca. You have it on the screen. If I don't get to all of your questions here today, we have a lot of information on our site as well. So already we have some questions rolling in. We have one coming in from David Guido this morning. David is asking, good morning. If a company lets you go because you found a better job, but also offers you a gesture of $2,000, but you have to sign your rights away. Should I sign? I've been with the company for 4.5 years. So what I'm understanding from your question, David, is that you've informed your employer that you're going to resign, you're leaving for another job, and they've agreed to pay you a $2,000 kind of going away bonus, and they expect you to sign a document which is typically called a full and final release in exchange for receiving that $2,000. Really, it depends if you have any issues with them, David. I mean, if you feel that they didn't pay you overtime, they didn't pay you vacation time or anything like that, and you want to bring claims for those kinds of amounts, well, you won't be able to do that anymore after you sign that document. However, in most cases, when people leave their job, they aren't entitled to any type of compensation. So it could be an extra $2,000 that you're turning away for no particular reason. It depends on if you're trying to preserve any rights to sue them for anything. So I don't know what you have in mind. I know you've put in a follow-up question here. Let me get to that right away. Now their vice presidents called my new employer and rudely demanded to find out if I took the full-time job or not. Oh, okay. Well, that might explain things. If they're going to try to sabotage you at your new job, you would have the right to sue them for defamation and potentially interference with your new employment contract, which potentially you would lose if you if you sign that document. So if you think that the departure is not going to be amicable, if they're going to try to give you trouble and make your life hard at your new job, then you might want to preserve your rights. You might want to be able to say, guys, you can't do this. I'm going to sue you now. So that would be my concern. You ask if it's a privacy breach. I don't know if it would necessarily be a privacy breach that they contact your other employer, but if they're saying bad things about you that are untrue, then that could be a form of defamation, David. So keep that in mind. Yeah, it could be defamation if they try to turn your employer on you, your new employer on you, rather. We have another question coming in from YouTube from Morgan. Morgan asks, hello, can an insurance company force someone into an inpatient treatment facility for 45 days for substance use? Job position in question is not safety sensitive and use has not been an issue at work. So, Morgan, I'm not sure whether an insurance company can do that. I think basically a court could probably do that, and short of a court, I don't know if an insurance company, short of a court order, I don't know if an insurance company could do that. If substance use has become an issue at your employment, and your employer is telling you to get treatment, then we got to qualify what they mean by force, right? If they say that if you don't go into drug treatment, you won't get long-term disability or short-term disability benefits, or they'll tell your employer that you're not compliant with treatment, which may result in you losing your job. That's kind of a consequence of not complying with treatment. If there's a drug and alcohol policy at your job and you're found to have breached it, and you're not willing to undergo treatment, it can result in you being terminated. All right, so that's what you have to keep in mind. Forced, if you get a court order, police can escort you to this drug facility, and you can be, basically interned there where you can't leave till the end of the treatment period. All right. But if by force you mean I might lose my job for this, well, that could be a consequence if you don't comply with, a treatment plan, if you've been found to be in breach of a drug and alcohol policy. So you've heard us here on the show say a lot that, a drug or an alcohol dependency can be a form of disability, which may trigger your human rights if you suffer consequences for having a disability. However, you have to also recognize, that you have this disability and take steps to receive treatment, essentially. So basically, an employer is not necessarily required, just because your drug or alcohol dependency is a disability, to allow you to continue to come to work or to use substances that go against the drug and alcohol policy. They have to give you a chance to receive treatment, but you have to take that chance. So that's what happens there. We have a question coming in from Mohammed. Mohammed Faiz Ahmed asks, can you have both severance pay and EI? So that's a great question, and we get that a lot from our clients. To explain that, I'll just give you a scenario. You're terminated, say, December 1st, and you receive a severance package, let's call it 3 months, just to use an example. So during that 3 months that you receive a severance package for, you can't also collect EI, okay? What will happen is that at the end of those 3 months, if you still haven't found new work, you can then start collecting EI. Now, the 3 months that you had a severance package for, you don't lose your EI weeks for that time. Say you're entitled to 52 weeks of EI, you'll get your 3 months, and then the 52 weeks will start after that time. All right. So you'll still, if you don't find new work, receive your full EI entitlements, but they will only start after you after you run through your severance package. So that's kind of how that works with EI. It was a little bit different during the pandemic. There was a period of time where you could receive both EI and a severance package for the same period of time. But that was a pandemic measure, and it's been ended now. So it's back to the way it was, that you would have to wait till your severance package is over before you start collecting EI. That said, as soon as you're terminated, the best practice is for you to apply for EI, so that your application is in the system and ready to be activated once your severance is over. We have a question coming in from Jebel on YouTube. Jebel asks, what is this time frame for signing a severance offer? My employer is pressuring me to sign. So Jebel, there's no legal time frame that you need to sign your severance offer by. Oftentimes, employers, what they'll do is they will put like a 1 week deadline, which is quite short, especially if you're considering having your severance offer reviewed by a lawyer. That can be quite short. Oftentimes, though, a lot of our clients will ask for an extension. Simply, if they are meeting with us on the 8th or 9th day and won't be able to return the signed severance back to their employer until after they've spoken with us, we advise them, why don't you contact your lawyer, say, listen, I'm going to have this reviewed. I just need a bit more time to meet with my lawyer. Can I have an extra week or an extra 2 weeks? And you might also need to, depending on the size of your severance, need to consult with your accountant and do some tax planning and things like that. So all of that takes time. And so, you can expect that your employer's vast majority of the time, it's not an issue to just ask for an extension. That said, it shouldn't be a 3-month extension. You should be able to make up your mind relatively shortly. What I also tell people is that if they decide, listen, Luc, I want to work with you, I want to try to improve my severance package, then, you don't need to sign by the date because you're not accepting their offer. So simply, you can ignore the timeline. It's not important if you're not accepting their offer. It's only if you're accepting their offer that it's important that you sign back by the agreed to date. So keep that in mind. Yeah. Now you might be wondering, is the severance that I've been offered, is that appropriate? Am I entitled to more? So the way that you would be able to determine that very quickly, 24 hours a day, 365 days a year rather, is you can visit our website. We have a severance pay calculator that's available free of use, no obligation. It's at pocketemploymentlawyer.ca. You have that on the screen there for you. So that is a very simple tool to use. We ask you just 4 questions to help you determine what your severance entitlement might be. And so if you want to compare that with what you've been offered to see if you've been offered a good package, it's always best to get legal advice from a lawyer, but you'll have an idea of whether it's in the ballpark or not, okay? It's always best to get your legal advice from a lawyer. And if you see that it's really not as good as it could be, then definitely there's an easy step from there to speak with one of us so that we can give you an idea of what an appropriate severance package would be in your case. So that's pocketemploymentlawyer.ca. We have another question coming in from Sam. Sam is asking, what is it reliable to properly check out in relations to be able to successfully disseminate a cease and desist letter? Sam, not a lot of context to your question there. A cease and desist letter, my understanding, should be sent to the person that you're actually asking to cease and desist. So if someone, for instance, is defaming you, spreading lies about you, you don't print the cease and desist letter in the newspaper. You send it to them, or you have your lawyer send it to them to tell them to stop whatever it is that they're doing. You want to make sure that it gets to them. So if you have an email address for them, if you want to actually make sure there are some legal requirements that you advise them in writing before you sue them, then generally you would have a process server bring it to their address. Either that it's an individual, you take it to their home address, have it hand delivered, or if it's a corporation, you send it to the corporate address. So that's generally how you would do that. David says, thank you for the information. My pleasure, David. I'm glad I could help. Paul Mislap put in an arrow. I'm not sure exactly which one that Paul was referring to. Paul, if you were trying to paste in a question or something, it didn't come through, so feel free to put it in the chat again. I'll get back to it. We have another question coming in from Reggie MacArthur. Reggie asks, what happens if you have to claim a human rights violation? Well, wife is not being brought back from maternity leave, and we think it's because of her leave. So unfortunately, that happens more than you would think, Reggie. And basically, that can be an instance of human rights discrimination based on gender, based on pregnancy. So your options in that case, you can, and it's not only a human rights violation, it's likely a violation of the Employment Standards Act or the Employment Standards Code in the province where you live. So when you take a maternity leave under the Employment Standards Code, it's a right-protected leave, and you have the right to be returned to your employer and to your position if you are terminated. Or if that position isn't offered to you upon once you're ready to return from your medical leave. So there could be other reasons other than the medical leave why your wife is not being returned to work. It could be that there was a restructuring in the department was eliminated. But oftentimes that's what the employer will say, but then what the reality is quite different. My advice to you, Reggie, would be to get in contact with us. Or to have your wife get in contact with us. We'd be happy to discuss this case with her to see if there's anything we can do to help to get her back into her job. I know it's quite hard, when you're returning to work after maternity leave, to have your, the rug, kind of pulled out from under you, all of a sudden you had this expectation that, EI would end and then you'd be able to start earning an income again. And here you are earning having to look for a new job. So we're always happy to help people that are in your wife's unfortunate situation. Have her reach out to us. The website is online here, is on the screen here, employmentlawyer.ca. We'd be happy to talk to her, see how we can help. Mohammed is asking, how long after employment can we dispute severance? And this is in relation to Mohammed's question, can you have both EI and severance pay? Mohammed, theoretically, in most cases, you have 2 years to start a lawsuit against your employer following your termination to ask a judge to provide you with more severance. All right, so that's 2 years. If there's a human rights element to it, it's you have only 1 year to bring a human rights application. If there are other elements to it related to employment standards, the delay can be even shorter. For instance, in Alberta here, you have 6 months to start an employment standards complaint. If you've been shortchanged on vacation pay, if you think you're owed overtime pay, if there were deductions from your last payday you don't agree with, things like that. So that's even shorter. But if it's just, listen, I was terminated without cause, I don't like the severance, I want to get more severance, that's 2 years to start the lawsuit. So it doesn't mean 2 years to write the first letter to your employer saying, can I get a bit more? It's 2 years to start the lawsuit. All right. So give yourself plenty of time if you are thinking of waiting on it. Of course, if you sign their release, that we've been discussing earlier today, the whole point of the release is to close off any avenues of court. All right. The release is there to say, okay, listen, we've settled your case. You're not going to sue us and we're going to pay you this money. So if you've signed the release, its effect is that you won't be able to sue them, not now and not, in 2 years, right? If you want to preserve your right to sue them for more severance, then you can't sign the release, all right? So very important. If you're wondering, is this good? Should I sign this release? They won't pay me the full severance until I sign the release. Get in touch with us, get in touch with us. We'll review your severance package. We'll tell you what we think, whether we think it's a good severance package and you should take it, or whether we think we can help you get a bit more. All right. It's an important financial decision. I know a lot of people feel like, well, I don't want to burn any bridges with my employer and I want to get a good reference and all of that. That's fine. I mean, asking for more severance or asking for a fair amount of severance shouldn't ruffle any feathers. It's par for the course. We do this, hundreds and thousands of times a year for our clients. And a lot of employers, most employers now expect that, they have to pay good severance. So don't feel afraid that you're going to ruffle some feathers. It's absolutely normal to negotiate the amount of severance that you're entitled to receive. We have another question coming in from Baldeep Hansra. Hello, I'm a current legal assistant student at SITE, and I'm looking into internships opportunities, and I was wondering if there are any at your firm. So great question, Baldeep. I know we do have legal assistant interns, but more in our Ontario office. So if you're in Alberta, you'd have to, not necessarily the department I work on, but you'd have to reach out to us. We have a student section on our website at employmentlawyer.ca. And you can submit an application there if you want to, and you can also see what positions we have posted. So look for the student section on our website at employmentlawyer.ca. But thanks for reaching out. I hope you're enjoying the show. Mohammed, again, thanks us for the advice. My pleasure, Mohammed. Always glad to help. We have another question coming in from FG from Reddit, is asking, my manager asked me to skip some training we are required to do and to say that I had done it. I am worried that if something happens or if the plant manager finds out, I will be in trouble. What should I do? Well, I'm worried too, FG, I gotta say. Generally, if you're required to do a training and to sign off that you've done it, then that's a problem if you actually haven't done it. That's a form of essentially misrepresentation or lying. And especially, if you're working in a plant, this might be a safety sensitive training. It might be training on, confined spaces or whatever it is, or training on the policies, the anti-violence policy, the money laundering policy. If they're asking you to do this training, it's because it's important. All right. So I would tell your boss, listen, I don't feel comfortable doing that. Can we ask for an extension? Maybe I can do it in the new year or something. But if you want me to sign off that I've done this training, I do need to actually do the training. I feel like I could get in trouble otherwise. So it's very important that you either give me the time to do the training now, or I'll do it. I'll ask for an extension and do it when there's time. But I won't pretend that I did a training that I didn't do. And it's unfortunate that it's your manager that's asking you to do this, because you're in a very awkward position now. If this persists, I would tell your manager, I would go above your manager or go to HR at least and say, listen, I've received this pressure to falsely state that I've done a training that I haven't done. How should I handle this? We have another question coming in from Facebook from John. John is asking, how is severance calculated if you have had gaps in your pay recently due to lack of work? Okay, great question, John. So generally, the four main factors that are looked at for determining your severance are going to be your age, your length of service, the seniority of your position, and the availability of similar work. Okay, based on your experience, level of education, and all of that. Now, that helps us determine a length of your severance period. So the severance period is often going to be expressed in weeks or months. All right. Now, say the length of your notice period is 8 months. All right. Well, what comprises that 8 months? 8 months of what? All right. So generally, it's 8 months of your total compensation. And basically what we ask ourselves is, how do you work that 8 months following your termination? What would you have earned? All right. So of course, we're going to look at historical numbers. If you're someone that's on a salary, you've earned $50,000 a year for the last 3 years, there was no talk of giving you a raise or cutting your pay before your termination, then basically that 8 months is going to be, $50,000 a year times 8 months, right? That's what your severance should be. But we also have situations where people are on commission, or over the last 3 years, as you had some layoffs that have resulted in fluctuation, or maybe not even layoffs, but reductions in hours that mean that your salary is fluctuated. So employment standards will always tell you, well, we look at the last 13 weeks, we average that salary out, and then we multiply by the amount of weeks that you're owed. And that's employment standards. That's how they do it for the minimum amount of compensation that you're owed under the Act when you're terminated. When you're doing it through us, we don't do that necessarily. We can use that if that's the best way to figure out how much you would have gotten over 8 months. We can use your 3 years average. We can use your last year's compensation. There's no hard and fast rule. In fact, what we're trying to do is, what's the best method that'll best approximate what you would have earned had you stayed there for 8 months. All right. That's what we're looking for. So sometimes the 3-year average is the best method. Sometimes last year is the best method. Sometimes the last 13 weeks is the best method. It varies from person to person for a variety of reasons, right? So basically what you have to kind of ask yourself is, what would I have earned had I stayed for an extra eight months? Well, I would have gotten, so much in salary. Over the last 6 months, work has been pretty stable, and I've been averaging, 37 and a half hours a week the whole time. There's nothing to indicate at the time of my termination that we were going to slow down or pick up or anything like that. So I'll use the 37.5 hours a week. It might also include benefits, the bonus you would have received, your car allowance, stock options. Everything you would have gotten during that 8-month period will form part of what your severance is made up of. All right. So sorry to give you the typical lawyer answer, John, but it kind of depends on how we calculate what it comes up. We're trying to get what you would have gotten had you stayed there for 8 months. And for you, if 8 months is the length of the severance you're entitled to. So it's of course, it's kind of a guess because you didn't stay there 8 months. So we're trying to find what is the best way of looking at that. We have another question from a LinkedIn user. If an employee's salary was reduced by 33% without their consent and they took it as a constructive dismissal and stopped working, does the employee have to go back to the employer to request a record of employment? So records of employment are usually supposed to be issued once you haven't worked for 7 days. All right. So if you've resigned and claimed constructive dismissal, likely what your employer will do is send a record of employment saying that you resigned to Service Canada. So nowadays, employers don't generally send you a paper copy of your record of employment. They send it directly electronically to Service Canada. So if you're wanting to make an application for EI, you have to create an account on the My Account portal of EI and submit your application. You can still submit it if there's no record of employment on there. EI will then follow up with the employer on where the record of employment is, or they might ask you to also follow up. But chances are by the time you go and submit your application, you'll see it'll be there. Don't be surprised if it uses the code Q in the sense that it says that you quit. So you can still submit your application and explain to EI, well, yes, I quit because they reduced my wages by a third and I didn't agree to that. And EI will investigate, and if they agree with you that that's a constructive dismissal, they'll entitle you to EI benefits. All right. So, but first thing is to go in there and submit your application. Don't sit on it too long, as I was saying earlier in the show. Mohammed Faiz Ahmed has another question. Another question. My employer is asking for references each time I appear for an interview. They are not reaching out to any of them. I feel like I'm burning bridges with my references as I ask them each time and they are not contacted, neither they move ahead with hiring me. So unfortunately, Mohammed, there isn't much legally that you can do about that. We all know how painful the hiring process can be, and it seems that your employer is not really doing a very good job of following through. I would say keep on looking for other work. It doesn't seem like they're very serious about moving forward here. It might be, that they ask you for additional references, after the next interview. Just tell them to contact the ones you've sent. I don't know how many references you've already given them. Tell them to contact the ones you've sent. Just send those names again, I guess is what I would say. But there's nothing really, there's no legal limit to how many references an employer can ask you for. If, it's up to you and them if you really want the job to submit references, and if they really want to hire you, for them to contact your references. Baldeep Hansra answers, okay, thank you so much. I'll check it out. Thank you, Baldeep, for listening in. And we have time for one last question. It's coming from Helen 2006. HRT may not make a dismissal may not make a decision in 2 years. If it proceeds a lawsuit from Supreme Court, what are the cons? A dismissal. So Helen raises a good point, and I think Helen is in BC. Is that court delays are an issue, and delays at the Human Rights Tribunal are also an issue right now in Canada, and throughout the country, unfortunately, at the very least in Ontario, Alberta, and BC, where we operate. So there could be issues, Helen. For instance, in Ontario, you can't go to the Human Rights Tribunal and to the court for the same thing. You have to choose one or the other. In Alberta, you can do both, and we often do both. We'll start a lawsuit and start a human rights complaint at the same time. And I'm not sure if that's the way it works also in BC. So you definitely want to make sure, though, that it's not like Ontario, where if you start a human rights action and then start a lawsuit, then your human rights action is going to get thrown out. But delays are definitely a consideration. So definitely something to discuss with us. If you're thinking of bringing in a lawsuit, discuss it with us. We'll tell you which is the best avenue forward, amongst other things, considering the delay that might be involved. So my name once again is Lluc Cerda. I'm the managing associate of the Calgary office of Samfiru Tumarkin. It was great having you here today. Lots of great questions. Thanks everyone for tuning in. We have another show coming up in tomorrow. We're going to be hosting a disability law question and answer period at 10 a.m. So feel free to make sure to join in. It's at 10 a.m. Pacific time with my colleague Martin Willems. He'll be joining us. Thanks again. And feel free to visit employmentlawyer.ca if you have any remaining questions, and we'll talk to you very shortly. Bye now.